hashtag Grok to tell me the story of President Lincoln canceling hashtag habeas corpus in the voice and style of hashtag Joe Friday from hashtag Dragnet. It is hilarious. Cue Dragnet theme music. Dun da dun dun. Dun da dun dun dun. This is the city, Washington, D.C., spring of 1861. The nation split, bleeding from a wound called secession. Wars brewing, and the Capitol's caught in a vice. Confederate sympathizers to the south, Union troops scrambling to hold the line. I'm a documentary filmmaker, chronicling the chaos. My name's Friday. I carry a notebook and a knack for getting the facts. Just the facts. It was April 27, 1861. The air was thick with tension, like a storm ready to break. President Abraham Lincoln. Not Rankin, ma'am, there's no record of a President Rankin in these parts. Set in the executive mansion, maps and telegrams strewn across his desk. The Confederacy had fired on Fort Sumter 2 weeks prior, and Maryland, a border state, was a powder keg. Baltimore mobs had attacked Union troops, derailed trains, and burned bridges to keep reinforcements from reaching Washington. The capital was cut off, vulnerable. Lincoln's orders were clear: keep the rail lines open, no matter the cost. At 0900 hours, Lincoln issued a directive to General Winfield Scott, commander of the Union Army. The president authorized Scott to suspend the writ of habeas corpus along the military line between Philadelphia and Washington. Habeas corpus, ma'am, is the legal lifeline that says no one can be locked up without a judge saying it's lawful. Suspending it meant the military could arrest anyone, rebels, sympathizers, or loudmouths, without a court's say-so.
Or 10 million illegal aliens.
Public safety. Maryland's unrest threatened the Union's survival. He wasn't asking for permission, he was acting. Enter Chief Justice Roger B. Taney, head of the Supreme Court, a Marylander with a sharp pen and sharper convictions. May 25, 1861, a man named John Merryman, a Baltimore secessionist, was arrested by Union troops for recruiting rebels. They locked him up at Fort McHenry. No charges, no hearing. Merryman's lawyers ran to Taney, sitting as a circuit judge, demanding a writ of habeas corpus to free their client. Taney issued the writ, ordering General George Cadwalader, Fort McHenry's commander, to bring Merryman to court and justify the arrest. May 27, 900 hours. Cadwalader didn't show. Instead, he sent a letter, polite but firm. The president had suspended habeas corpus, and Merryman wasn't going anywhere. Taney was livid. He tried to serve a contempt notice, but soldiers at the fort blocked the messenger. The next day, May 28, Taney issued his ruling in ex parte Merryman. His voice echoed in the courtroom, steady but scalding. Only Congress, not the president, could suspend habeas corpus. Article 1, Section 9 of the Constitution was clear: suspension was a legislative power, not executive. Taney argued Lincoln's order was unconstitutional, a dangerous overreach. He sent his opinion straight to the president, expecting compliance. Lincoln didn't blink. He ignored Taney's ruling. Military arrests continued. Merryman stayed locked up, and more followed. Lincoln.
So, President Lincoln ignored the head of the Supreme Court, Chief Justice, and went ahead and suspended habeas corpus anyway. But you'll hear the rest of the story, how it got codified into law.
Lincoln's logic was simple. The Constitution allowed suspension, when in cases of rebellion or invasion the public safety may require it. Rebellion was here, clear as day. Congress wasn't in session when the crisis hit, and waiting could have meant losing the Capitol. He acted to save the Union, law be damned. By July 4th, when Congress finally convened, Lincoln defended his actions in a message to both houses. He asked, "Are all the laws but one to go unexecuted, and the government itself go to pieces?" The arrests went on: politicians, newspaper editors, anyone stirring trouble. Congress didn't rubber stamp Lincoln's move right away. Senator Henry Wilson introduced a resolution to approve the suspension, but it stalled. Democrats cried foul, and even some Republicans, like Senator Lyman Trumbull, worried about the precedent. Trumbull proposed a bill to suspend habeas corpus under Congress's authority, but it died in the first session, blocked by filibusters and fear of giving Lincoln too much power. Meanwhile, Lincoln doubled down. September 17, 1861. He ordered the arrest of pro-Confederate Maryland legislators before they could convene and vote to secede. No charges, no trials, just cells. The tide turned in 1862. By December, the war was grinding on.
So Lincoln then put in jail all the Democrats who were going to secede from the Union.
The tide turned in 1862. By December, the war was grinding on, and public safety still hung by a thread. Representative Thaddeus Stevens introduced H.R. 591, a bill to indemnify Lincoln for his suspensions and clarify his authority. The House passed it, but the Senate had other ideas.
H.R. 591, a bill to indemnify Lincoln for his suspension of habeas corpus. It is the law of the land. The president can do it under an emergency like an invasion or a civil war.
They amended it, stripping the indemnity and asserting Congress's own power to suspend habeas corpus. The conference committee hammered out a compromise, the Habeas Corpus Suspension Act, signed into law on March 3, 1863. It authorized the president to suspend the writ nationwide, wherever he deemed necessary, for the war's duration. Lincoln used it 6 months later, September 15, 1863, suspending habeas corpus across the Union for cases involving prisoners of war, spies, traitors, or soldiers. The act wasn't a blank check. It required the military to report arrests to federal courts and release prisoners if a grand jury found no cause. But in practice, Lincoln's word was law. Thousands were detained, some rebels, some just critics. The Supreme Court never revisited Merryman, and Taney's...
So that's the story. My name is not Joe Friday, but I liked having Joe Friday tell the story. Anyway, let him finish.
The Supreme Court never revisited Merryman, and Taney's ruling faded into a footnote. By 1866, with the war over, the court in ex parte Milligan ruled that military tribunals couldn't try civilians where courts were open, but by then, the suspensions were history. That's the story, ma'am. Lincoln acted alone, defied the Chief Justice, and got Congress to back him, eventually. The Union held, but the cost was a legal precedent that still sparks debate. Just the facts. Dun da dun dun. Fade out.